In this video, I'm going to give you a quick overview of the fair use doctrine in U.S. copyright law. However, I should warn you, this doctrine is much more complex than this video will be able to show. I'm going to add my ebook on fair use to the course as a bonus, so you can read more about this important part of copyright law. However, as I've said before, this part of copyright law is tricky enough that it might be a big benefit to you to hire an attorney. They can give their opinion on whether or not the infringement will qualify as a fair use. When someone infringes your copyright, they may present fair use as their affirmative defense. An affirmative defense is one where someone admits to doing the bad thing, but they basically have an excuse that makes it okay. This is where fair use fits in. It's someone admitting that they have indeed infringed on your copyright, but there's an excuse from liability. Fair use exists to put limits on the power of copyright protection. This is so that legitimate uses of copyrighted material can be made lawful. Congress specifically specified things like criticism, comment, teaching, and news reporting as being exempted by the fair use doctrine. In order to decide whether something's fair use or not, the law gives 4 factors that a court is supposed to weigh against each other. None of the factors can make the decision on its own. The court is supposed to look at all 4. That way, even if one of the 4 factors is heavily against the infringer, the other 3 could swing their way and make it a fair use overall. So what are the 4 factors? The first is the purpose and the character of the use. This looks at whether the infringing use is one of the types that we mentioned before, like criticism, comment, or education. It also looks at whether or not the use is for commercial purposes, which makes this factor weigh against the infringer. The second factor is the nature of the copyrighted work. This looks at whether the original work was more creative or whether it's more factual in nature. The court will also look at whether that original work has been published or not. Basically, fair use is more likely in cases where the work is more factual and has been published. Unpublished works are less likely to be fair use, but it's not a hard and fast rule. The third factor is the amount and substantiality of the portion used. The court looks at how much the infringer used compared to the entire thing, and how important that piece is to the entire work. If they take in the heart of the copyrighted work, or they take in a substantial portion of the work, then this will weigh against the finding of fair use. The last factor in a fair use analysis is the effect on the potential market that the use of the original work has. Generally, they'd have to show evidence that this taking of their work has caused some harm to the potential sales of that work. However, there's a presumption that the use will do this, so it's up to the infringer to prove otherwise. This is just a quick overview of the fair use doctrine. I invite you to check out the ebook I wrote. It's attached as the next assignment for a more detailed look, along with case excerpts and some sample fair use analysis. And above all, if there's a question of fair use, an attorney should be the one doing the analysis to ensure a good faith belief that the use isn't fair before the takedown is sent. The takeaway here is that when you're doing this second step and determining if there really was copyright infringement, you need to look at fair use. If you believe that there's a legitimate fair use claim, then a takedown would not be appropriate.